Yes, Mr. Horn.
Lord Lady, can I make just 2 points?
2 points, yeah.
Well, first of all is to summarise my position with paragraph 27, which Justice Carr asked me about before lunch.
The judge's paragraph 27.
That's right, the judge's paragraph. And simply, in subparagraph 1 is incorrect, I say. 2, there are no such emails.
Sorry, let me just get it out so I've got the 1s and 2s in front of me. No such emails.
No. Thirdly, the email of the 19th of November 2014, which is the one from the Royal Borough of Kensington, Chelsea, which well, that is what it is. It's got to be seen in context. It was before the key date of the 14th of December. The actual attitude is evinced by what's it came to be. What was the attitude? Is evinced by the letter of 9th of August 2022. It's in any event irrelevant given the terms of clause 9 because it didn't matter why there was no certificate if there was none. Fourthly, the correspondence referred to in subparagraph 4 is all before the relevant date, which is the 14th of December. It's accepted that there was no documentation prior to that in the lead up to the sub-lease. And fifthly and sixthly, the judge deals with detriments, and I say he takes an unwarrantedly narrow view of the detriment which he says my client has to prove.
Yes.
And finally, can I deal with the point that Lord Justice Nugee raised just before in respect to my entitlement to make the point? Simply make 2 points. If you look at paragraph 30 of Mr. Pett's submissions, written submissions, to the judge.
It's tab 12.
It is tab 12, page
Paragraph
145. Yes. Paragraph 21.
21.
At page 149 is the paragraph that's quoted by the judge.
Yes.
Mr. Pett's helpfully sets out the question. If you look at go on to paragraph 30, at page 151, Mr. Pett says this: the real issue is whether C occupied under the underlease or as a periodic tenant. C's case is so weak on this point that the court would be entitled to find that there was no serious issue to be tried. Even if the court is not so satisfied, the strength of D's case on the undisputed facts may be rightly taken into account at this stage.
Yeah.
And as I said, I've taken you to the passages in the French skeleton to the judge. So I say it is open to me. And in any event, and finally, the grant of an injunction is an equitable discretionary remedy if this court felt that even if the judge had been invited into error by one of the parties, it's able to this court to say so. Thank you. Those are my submissions.
Yes, Mr. Moffat. We needn't trouble you on ground 1.
I'm grateful for that indication, my lord. Honourable Lady, if I may, I'll start where my learned friend has finished, which is on the first 3 subparagraphs of 27 of the judge's judgment, which is goes to the question of Mr. Moavan's state of mind at the time in question, and to give substance to the submissions that were accepted by the judge. You were taken to some of the correspondence, but not all of it, by my learned friend. You were taken to the correspondence. There's a series of emails that begins at the supplemental bundle at page 242. And you were taken up to page 252, and then, but not to those that followed. And I'll draw your attention, if I may, to page 253.
Starting at 242, yeah?
You were taken, well, when you were taken to these...
You want to go to 253?
Yes, please. Page 253, the bottom of 253 is an email from Mr. Vickerstaff at the Counts at the Borough to Mr. Moavan, saying, I confirm that we've done our 28 days on this now, and so we'll be able to look to complete on Friday next week after formal approval is gained on Thursday morning. The inference we may draw here is that that is approval of the deed of that goes behind the deed of variation.
What's the 28 days?
Some internal, I take it to mean some internal
Right.
mechanism at the council that they have a review period. I didn't draw any other specific or any legal significance to that period of time. That email is forwarded to Miss Delaney on the 23rd of September 2014. So this is after the date of the lease has been granted, before occupation and before the deadline for the production of the deed of variation. It says very simply, dear Francis, please note my exchange with the council. Now, the evidence below was that Mr. Delaney doesn't recall receiving that email, but she says that if I had, then it would have told me that everything was in hand. In other words, this is an email that intended to be reassuring to her, and that in hindsight, if she had received it, it would have had that effect. And that, in my submission, is a fair inference to draw from both the intention and the effect that email would have had.
The 28 days, Mr. Moore, which you'll find explained on page 250. Council has to give the public 28 days notice of any executive decisions it is proposing to take.
I'm very grateful, my lord. Yes, it's a public notice requirement. The next document at page 254 is correspondence on the 30th September 2014. And this is significant because it was raised in submission as to whether there'd been any involvement of Mr. Marvin of Avondale's lawyers post the grant of the lease on the 9th of September. And the judge below was right to find that there was, because this correspondence shows the involvement of Vitalis LLP, who were the lawyers acting for Avondale. And on the 30th of September, they write to Hunters, who had acted for Mr. Delaney's nursery in the conveyancing that led to the lease, saying, I write further to this matter and close the underlease of whole executed by my client. I confirm that I will forward information in relation to the deed of variation as soon as the same is received. So what it demonstrates is both that Mr. Marvin and his solicitors are both conscious of the need for the deed of variation, and therefore it must be taken in my submission that they are aware of clause 9. So Mr. Delaney's evidence is that she was busy opening a school nursery for the new term, the beginning of a new school year. She had a new influx of children that she was under her care, and she was preoccupied and didn't advert to clause 9. But the same cannot be said of Avondale, which both did advert to it, and so did its lawyers who were on hand. If I could...
Well, Mr. Moffat, the fact that Mr. Moore and his solicitors were aware of a need to obtain a deed of variation shows that they knew that the change of use was required because under the head lease, the use permitted was residential. It doesn't necessarily follow that they had appreciated the effect of clause 9.
No, my lord, I accept entirely that's right, but this would clearly be a matter for legitimate cross-examination as to the state of mind of Mr. Marvin, which would have to be a tribal issue. And that it is, and I would put it this high, that it is no stretch to make the link that if you are aware of clause 9, because that is the origin of the obligation to provide the deed of variation, that you've read it. And if your lawyers are aware of the obligation to provide the deed of variation, which the source of which is in clause 9, that they've read it too. And it is in my submission, as per ground 1 of this appeal, an obligation which is plain in its language and as to its effects, it absolutely stares you in the face. So it is no stretch at all to consider that Mr. Marvin and his lawyers were alive to the consequences of the non-production of the deed of variation. If I can pause there, and forgive me for interspersing, but it needs to be seen alongside what Mr. Marvin says in his evidence about this, and I'll come back to page 254 to please keep that. But he says that his witness statement begins at page 214. And his evidence about what he understood to be going on at this time begins at paragraph 15, which is page 217. He says at paragraph 15, in the meantime, the planning application was going ahead, I paraphrase. And then it then says, Francis Delaney and I kept each other informed as to the planning application and deed of variation, and I told her that the variation was agreed with the council. It was just a matter of agreeing with them the terms of the deed. Now, we submitted that that evidence is false for the reasons I'm about to take you to in the correspondence at the time. It was denied by Miss Delaney in her evidence that she was kept informed about the deed of variation. And other than the one email that I've taken to you, which forwards Mr. Vickerstaff's 28 days comment, which I've submitted is obviously intended to be reassuring to her, there's no email that is produced in evidence regarding the deed of variation to her. And she denies there was any conversations about it. Paragraph 17, he says, in fact, the deed was eventually agreed on the 11th of June 2019. I did inform the claimant of this at the time. That again is disputed as a matter of fact. Mr. Delaney says that she wasn't informed of that. Furthermore, you may have seen in submissions and in the evidence that the deed that's been produced bearing that date some years later is only executed by Mr. Marvin, not by the borough. There's a copy of it at page 275. And the signature page is at 277, signed by Melcroft, which is Avondale's predecessor, of course, but not by the council, by the borough. And what is also, going back to Mr. Marvin's witness statement, paragraph 17, and why this is so ripe for cross-examination at trial, is that he doesn't actually explain what the cause of the interval was. What was happening? What was the problem?
Well, we know there was a problem. We know what it was. Certainly in 2014, don't we? From 2006.
We know, my lady, absolutely. We do at that point in time. But obviously there was some, otherwise a continuation of that problem that made it last for 5 years, or some new problems, or different problems that he's chosen not to share in his evidence. So it shows a lack of candour. It obviously calls for explanation. We still haven't ever been produced with a deed of variation that's executed by the borough.
But is your point that it's clear from, I know you're about to take us to these two emails, the solicitors were onto it. It's November, there's a degree of urgency which suggests, perhaps to be explored, don't know, an awareness of the impending deadline, because there's urgency in these two emails. And then in the 5 years, if there's focus on trying to get the problem sorted, is there the possibility of people turning their minds to clause 9? Is that your point?
Well, it wasn't the immediate point I was going to make, my lady, but clearly that point does arise. Yeah. The immediate purpose of taking you to these documents is to go behind my learned friend's repeated submission that his client, Mr. Marvin, was proceeding under the assumption that the lease, the written lease, was subsisting. I'd say that's very much a matter for cross-examination, a triable issue. Indeed, I would go further to say there's considerable doubt cast upon that by the lack of candour in his evidence, where you would expect him to explain these things, and doesn't. And indeed from what he does and doesn't choose to share with Mr. Delaney, which I'll come back to. oddly and contradictorily, returning to his witness statement at paragraph 18, he says the deed was not discussed between the claimant and Melcraft after the claimant took possession of the property, which seems to undo what he's just said in the preceding paragraphs about keeping her updated. So he otherwise did or he didn't, but he seems to be saying both. And then...
Well, it's curious phrasing anyway, because there was no deed until 2019.
Yes.
Signed by anybody.
It's an impenetrable... It's a very brief witness statement that doesn't go into the sort of detail that you would expect of... and transparency you'd expect in the circumstances, unless there's something to hide, of course, which is what cross-examination in a trial will be aimed at eliciting. But yes, it suggests there is a deed in existence, and he would need to expand on that if there were. But that's never been the submission advanced on Avondale's behalf, that there was a deed earlier than this 2019 unilaterally signed on. And then at paragraph 19, he says this: thereafter we proceeded as per the terms of the underlease. Now, this was something picked up on below and something on which Mr. Justice Leech placed reliance. That's not the same as saying, I believed that the written lease was subsisting. In fact, it's deliberately quite coy in my submission, conspicuously coy, as to what Mr. Moavin's state of mind was at the material time. And this, of course, all goes to ground 2 and the estoppel point because of something crossing the line and a shared assumption. Was it shared would be something that would have to be investigated at trial, because he's not saying either I believed it subjectively. He's not saying I wasn't sure, but I relied upon Miss Delaney's apparent certainty about it. Or that something Miss Delaney ever did or said procured in me a change in my behaviour or reassurance in my view or anything like that, that it produced any sort of causative effect upon him. And to complete the submission referring to the contemporaneous emails that he has exhibited to his witness statement, I was at page 25.
Suppose if there had been an automatic termination of the sub-lease on the 14th of December, and if the taking of possession and the payment of rent had created a periodic tenancy, which is a conventional common law answer, it would have been, quote, as per the terms of the underlease, unquote, except insofar as they were inconsistent with the periodic tenancy.
Precisely.
So to say that we proceeded as per the terms of the underlease is equally consistent with either outcome.
Precisely, my lord. I mean, that, which could even lead to a finding that, depending on the cross-examination and the evidence he gives about this, that he actually thought there was a periodic tenancy himself, because he'd taken advice on it. He doesn't disclose what advice he was receiving
No,
at
he
the
doesn't
time.
have to.
He doesn't have to, no. But he could choose to or not, and that's, I mean, he's chosen not to, so we don't know. But it is, of course, feasible that he's been told that there's been a termination. The factual background is also that this is a lucrative lease for Avondale, because it's the annual rent payable by Mr. Delaney's was £118,500, and the rent he's paying to the borough was £20,000. Now, and that led to my submission below that the inference that might be drawn is that actually he was just happy to take the money, if I could put it that bluntly, that whilst Mr. Delaney was apparently unaware of Clause 9 and hadn't, or at least hadn't communicated anything about it, he might be quite relieved and happy to continue to receive this very lucrative rent. Because Mr. Delaney says in her evidence, had I adverted to Clause 9, Had I known that I didn't any longer have a lease, my bargaining position had changed. To paraphrase her evidence, she says I was in a bit of a bind at the time and I had to pay a very high rent, which I wouldn't do and I wouldn't agree again had I known about Clause 9 and its effect. So there is a benefit to Avondale in continuing to receive the rent at a very high rate and not to avert to the fact that the lease had terminated. But coming back to the correspondence, I took you to page 253, which is what I've described as the reassuring email that Mr. Marvin has chosen to forward, giving the impression, I say, that everything is in hand. There's the letter on 254 on the 30th of September, which is the solicitor's letter. 255 is an exchange with the borough, seeking the deed of variation. It's now November, so the 14th December deadline is approaching. The last request is from Avondale's lawyer, Christina Dinellu, which is at the foot of page 256 on the 11th of November, asking for a timeline for provision of the deed of variation. And then the response is the significant one at the top of the page on the 19th of November from the borough, saying your client has significant arrears across the portfolio of properties he rents from the council. And then there's details about that. And it says our cabinet member was not convinced that this transaction represented best consideration for the council under the LGFA. So we are currently reviewing the valuation with a view to resubmitting the cabinet before he will give approval for the change to proceed. Your client in the meantime should clear his rent arrears. Now, in contrast to the reassuring email that was shared earlier, this email, saying that it isn't being approved, wasn't shared.
This is coming back to the idea they might want some more rent, is it?
It appears that they want...
The addresses in the boxes are not the property we're concerned with, are they?
No, the address is Avondale Park, but the...
and what
he's in arrears on other properties. Sorry.
What the inquiry is when can we expect the draft deed of variation? So when Ms. Maluta says our cabinet member was not convinced this transaction represented best consideration, she presumably is referring to the deed of variation.
Yes, that's how I think that's how it can sensibly be read. And after all, it is the only document that Mr. Marvin has seen fit to share that gives any explanation as to why it didn't transpire. There is some sort of problem, and not an easily surmountable one necessarily, that he isn't passing on to Mr. Delaney. So Mr. Delaney's in the dark about this. All that she's had is a reassuring, she says she doesn't remember receiving it, but there's a reassuring email that's forwarded to her, but not the problem, which is not highlighted to her, which suggests in my submission that Mr. Marvin is picking and choosing as to what he discloses about what is going on. The other point about this exchange is that this is now November 2014, and it's Avondale's lawyer that is in communication with the borough. So there was a question taken earlier in my learned friend's submissions about how it could be that Mr. Justice Leech had commented on the continuing availability of legal advice to Avondale. And this is why, because it's clear that, again, Clause 9 performance is still in mind, at least until the 19th of November, possibly after. So returning to Mr. Justice Leech's 6 reasons, and the first 3 of them, paragraph 27 of his judgment.
We're going back to the judgment.
My Lord, yes, just to remember where we I had started where my learned friend had
Yeah.
finished, and he had professed that there were not to be aware of some of the bases for some of the findings the judge had made, and this answers, I think, those points. At the first of those reasons, there's no clear evidence that Mr. Marvin himself proceeded on the clear assumption stated by Mr. Petts, i.e. the assumption that the written lease was subsisting. And the judge makes the point that I've directed you to, that his evidence is rather thin, where you might expect it to be fuller if it were candid, and doesn't in turn say he understood the written lease to be subsisting.
Yeah.
So we cannot be confident that the assumption on which the whole estoppel is premised actually is one that Mr. Marvin and Avondale held themselves. The second of those reasons is that my submission that the court should draw the inference that Mr. Marvin indeed was aware of Clause 9 and its effects, that it had come to an end, but chose not to reveal that information to Mr. Delaney. Now, of course, I can't invite a judge on an injunction hearing to make any finding to that effect, but clearly that would be the line of cross-examination and a possible reading of this evidence that would, as I say, is obviously a triable issue, maybe the outcome of that trial. And it's the email chain that he refers to that I've just referred you to. And the third, it's also clear by the middle of November 2014 the council was not prepared to enter into or execute the deed of variation to enable the defendant to comply with Clause 9. Mr. Moffat took me to an email dated 19th November. That's the email to which I've just...
Sorry, which paragraph are you looking at? Oh, it's 3.
This is the third of the reasons.
Yeah.
I had understood my learned friend to say that he wasn't aware what the evidence for that was, and I've taken you to it to make good on that submission. And the judge is right to conclude that the relevant council member was not prepared to approve the deed of variation at that point, which he wasn't. That's clear from that email. The fourth point I see is also answered by the passages I've taken to you. It's clear that the defendant was receiving legal advice during this period. Well, that he had his lawyers on hand and involved. I think it's one way further, they were talking to each other, which would amount to legal advice. And that leads to the conclusion that I cannot be satisfied, therefore, there was a convention shared between the defendant and the claimant. Allowing for the fact that at trial, the court may be persuaded that actually Mr. Morgan was fully aware of Clause 9 and its effects. It wasn't induced by any sort of estoppel to believe otherwise.
So is this the point that's why you say that pre 14th December material is relevant? Because it goes to Mr. Marvin's state of mind at the date when the nursery took possession, which I think he says was the 18th of December.
Yes, it doesn't. That's accepted. Yes, it was the 18th, not the 14th. And we say absolutely, where an estoppel is raised, at the heart of which are the states of mind of the parties, and whether one has induced or has assumed responsibility for a belief engendered in the other, and is thereby stopped from resiling from that belief, that it has encouraged the other party to hold with it. It's obviously clearly significant to investigate those documents and his evidence as to what he actually thought at the time, which is far from transparent and far from reaching the conclusion, far from leading to the conclusion my learned friend submitted that he assumed that the written lease was subsisting. That is a highly contentious conclusion, which isn't actually, I don't think, is available. It's unlikely on the evidence that you've seen that he did. I started there. I think there's an important overall point which I'd like to address to you, which is that the striking feature, we say, at the heart of this case.
You're going to come back to 5 and 6? Or you're going to deal with them now? I mean, it's up to you.
May I see whether I can conveniently do so now?
It's detriment. But you may want to come back to that later.
Yes, if I may. I say that, well, I will foreshadow it by saying that detriment is one of the glaring holes in my learned friend's submissions, that he's unable to show it. The estoppel would not arise because clearly his client was not realistically in a position to run a nursery school. It's fanciful. And without that, there's no harm, there's no detriment, there's no estoppel. And more than that, I mean, at the centre of this case, we say, is a gulf in the harm that would be done to the respective parties by the grant or refusal of the injunction. On the one hand, refusing the injunction would mean the closure of a school. It would have meant turning away its pupils, the parents that relied upon the childcare and education it provided, the early learning places it provides free to the borough, the staff who rely for their livelihoods on it, and of course the reputation of the lady whose name the school bears, which would be destroyed.
Is that what you do with estoppel? You say, I balance the detriment against the hardship that would be caused by allowing the party alleged to be stopped from resigning? Is that what you do?
Well, no, I've trespassed into the balance of convenience test on American sign limit. I appreciate it.
If there's an estoppel, there's an estoppel, isn't there?
Yes, but coming to the second point, which is relevant to the estoppel, is contrasting with the harm or lack of it to Avondale.
I understand your point about detriment. I'm just not quite sure where this balance comes in.
Yes, I appreciate it. I'm addressing a point on American sign limit, whereas this is not purely an estoppel point. But clearly the justice of the case and the decision below was overwhelming in favour of allowing this school to continue and open its doors. But the contrast with the detriment that wouldn't be suffered by Avondale is striking, and that's what's relevant to the detriment that would be material to an estoppel but doesn't exist. And in my submission, it leads to you have a professional landlord, Avondale, whose business is, as it's only ever been, being a professional landlord. It's a property business. It's never operated a nursery school. It wasn't in a position to do so at the hearings below. At the time of the hearing before Mr. Justice Leech, on the 8th of September, its own head lease was about to expire. Just had 5 days remaining. It has now expired, of course. Its landlord had not agreed to renew its lease. And Avondale had no realistic claim to renewal, which the borough had indicated in fairly robust terms in my submission that it wouldn't agree to. It said in correspondence it took the view that it hadn't been operating a business from the premises. And that's, of course, important because without a realistic prospect of running a nursery business, there's no detriment. Not only for the balance of convenience test, but also for the estoppel on which I'm addressing you.
Well, at some stage you better show us. Is that the response we saw?
The evidence going to the credibility of opening a nursery?
No, the borough's response.
I will. You've been taken to the document already, but I will take you to it.
All right. If that's the document we've seen, then we've seen it.
You weren't taken to the particular paragraph. I don't think.
You saw a letter to your client.
Yes, it's the letter to my client. It's not directed to Avondale.
Yeah.
But it states the council's position should on whether Avondale would have a right to renewal under the 54 Act. And it's at page 1. The letter starts at 154. It's dated 9th of August 22. The paragraph in question is on page 155. Second page of the letter, beginning at the second hole punch, the council is fully aware of the facts. You were taken to the beginning of that paragraph, but I'm not sure to the remainder of it. It says it's demonstrably, third sentence, it's demonstrably clear that the council would have been aware in view of the application and sub-lease the leaseholder would henceforth not be present on the premises for the purpose of carrying on a business. We have little doubt that a court of law will make such a finding. We do not see any basis for the council to consider otherwise. So it's answered that it doesn't. It takes the position that there wouldn't be any continuation tenancy for Avondale in these circumstances. I should say this leads to a further and wider point, which Your Lordship touched on at the end of my learned friend's submissions in the warning, which is that it renders the appeal pointless because Avondale's head lease has expired. It's fanciful to suggest that Avondale has already done anything to acquire protection under the 54 Act. In fact, in its submissions below, it wasn't its case that it had acquired 54 Act protection in that narrow window of time between the 26th of August and the 5th of September, 26th of August 22, when it had changed the locks, 5th of September, when the first injunction hearing before Mr. Justice Mead took place, in which it was ordered to give up possession back to the nursery. It would have therefore no basis whatsoever to argue as against the borough that it's been carrying on a business for the purposes of the 1954 Act. So even if this appeal was successful, we submit that it shouldn't be. It would be of no assistance to Avondale in any event. It wouldn't return Avondale to occupation of the premises, because that would be a matter for the borough, who isn't a party to these proceedings. As I say, it's indicated its opposition to Avondale. It hasn't agreed with it a renewal of its lease in the first place. It has stated it doesn't think it has a continuation tenancy or any rights under the Act. It might paraphrase. Ms. Delaney has stated in her evidence her belief. She reasonably believes that the borough look on her favourably and would deal with her directly and grant her a lease. And indeed, she's still there. So Avondale would be in a position where, even if its appeal is successful, it wouldn't be restored to the premises. It would then be fighting litigation on two fronts: the litigation of the claim with my client, and potentially a litigation with the council, with the borough, over whether it had protection under the 54 Act. It would have to succeed in both in order to establish its right to possession back into the property, which is some distant prospect. In the meantime, who would grant an injunction to oust the current nursery school? We'd be in the same position as we were before Mr. Justice Leece on the balance of convenience. It's a pointless appeal.
I think you're mixing up two different scenarios. What you started off by saying was that if we allow the appeal and discharge the injunction, it would be pointless because Avondale wouldn't get back in. But that is only a matter, isn't it, between Avondale and RBKC? It's not a matter between, if the injunction goes.
Yes, but if my client is right in her evidence that she reasonably believes that the borough look favourably on her because she provides education in the borough, and she's in her evidence she says that she reasonably believes that they would deal directly with her in granting her the company a new lease, and she says why. And one of the reasons she gives is that they provide free early learning places for children in the borough. We know that the borough have expressed a view antithetical to the renewal of Avondale's lease because it says it doesn't have protection under the Act, so to speak. And we know that it declined to reach an agreement about a new lease with Avondale. So knowing those facts, we can only conclude that there would be some litigation. Yes, my client wouldn't necessarily be a party to the proceedings, but would be involved in the sense that the borough would say, we want to continue this nursery continues here, and we would have to evict them, which we are not inclined to do. My client would say, we have statutory protection because we're a periodic tenant whose tenancy hasn't been terminated. So it would then become tripartite by those means. It would have to, because it would be beyond the power of the borough to give vacant possession unless they evicted my client. Hence the appeal is pointless, because it won't restore Avondale to the property. It just wouldn't have the effect that it apparently wishes for. And meanwhile, in the background, Avondale is not running a nursery business. So it wouldn't be in any on any interim hearing of who should have possession in the meantime, pending these various disputes that have now become tripartite, there's no prospect of anyone granting an injunction to remove my client to replace it with a business that can't run the nursery. So we say it's a futile. We say it is nugatory, this appeal. So you may have detected in my learned friend's submissions that now that its intermediate lease has expired, it has to change its position and say that it has already acquired 54 Act protection in that narrow period between 26th of August and 5th of September. But of course, that wasn't the position that it was submitting below. I say that's completely untenable. It wasn't even its case. And there is no evidence before you that it did anything in that period during which it locked out my client from the premises.
Well, there was a reference, wasn't there, in Mr. Peck's skeleton argument to the Poynton case, which must have been deployed for a reason.
Yes, but there was no evidence. There was no evidence on which that could bite, in the sense that...
Well, the evidence Mr. Marvin gave in the witness statement, which I think was the 6th of September, was that he'd arranged for an electrician, a plumber and a builder to go in on the 12th.
Yes. Okay. My lord, the evidence of relating to this is in Mr. Marvin's witness statement.
Yeah.
And exhibits. So his evidence about it is at
page 220.
I'm grateful. It starts at 220 under plans to set up
applying for Ofsted registration, change the nature of its business, company's house, and in the meantime it's intending to refurbish, and on the 12th September plan for an electrician, plumber and builder to go in and decorate.
And in my submission, my lord, that the important point there is the future tense. He's intending to do something. Whereas my learned friend now has to say its case would be that it already has done something.
Yes, well, I think he says that had Avondale been allowed to go back in when Mr. Justice Mead granted the injunction, it would have, on the 12th, started preparatory works for this business in the property, consisting of the electrician, plumber and builder, and by analogy with the Poynton case, that is, or at any rate may be, enough to attract the protection of the Act.
Well, yes, well, there'll be two responses to that. Firstly, it wouldn't be. The Poynton case, I don't want to take up too much time going to something that's actually quite marginal in its potential relevance. But Poynton was a case in which a financial services company already had a lease of other parts of a building, other than the ones which were the subject of the proceedings. It was already licensed, having everything in place, and it had employees. The premises in question were a different part of the building, and going into occupation of them would require very little. As the court found in that case, you just need a desk and a phone, and you'd start selling your financial products or give your financial advice or whatever it was that they did. And therefore, on those particular facts, it might be enough just to refurbish, because there was nothing else to be done. They didn't manufacture anything there. They certainly didn't have children coming through the doors and being educated. So on those very light facts, very specific facts, those light, if you like, was about as much as you would do to show occupation for that particular business. Because that particular business was people sitting in a room on the phone, doing their work. But the more fundamental point, my lord, is this: we don't get to Poynton and consideration of what would have happened after the 12th, because Avondale's lease has now expired. So any feasible claim it might have to 1954 Act protection would have to depend upon something it had already done. And in that respect, it can only point to, my learned friend in his skeleton argument has to point to the activity that he says took place between the 26th of August, when it came and changed the locks, and the 5th of September, with the hearing before Mr. Justice Mead, who ordered the return of the keys to my client. And the problem with that submission is that there's no evidence that anything happened. I think your lordship has already made that point to my learned friend. Certainly, planning and discussion with potential future employees of the business is not carrying on a business. And it certainly isn't in occupation of the premises under a tenancy. A further point arises that, as my learned friend accepts, on the 26th of August, when Avondale went back into occupation of the premises, they did so unlawfully, because that was an unlawful re-entry, forfeiture by re-entry, but based upon non-payment of rent. Now, my learned friend accepts quite rightly that that wasn't lawful, because that breach, the non-payment of rent, had been waived, because there'd been commercial rent recovery process had been engaged, which was inconsistent with the, consistent only with the continuation of the lease. So they weren't entitled to come and change the locks on the 26th. It was an aggressive act, as Mr. Justice Leech found, that sort of ramped up the pressure on my client. It wasn't lawful. Now, we can hardly rely on acts done during an unlawful period of occupation in order to support a claim for protection under the 54 Act on the basis that it was in occupation of the premises under a tenancy for the purpose of carrying on a business.
But wouldn't the occupation have become lawful when your lease by estoppel came to an end? Which was only a couple of days later.
I understand the point, my lord. Yes, at least for the initial 3 days, they can't rely on any act in that period. So you're down to the few days that followed, the 5 days that followed, in which there's no evidence that anything at all happened anyway. I mean, it's rather academic, the distinction between those two periods, because nothing happened in any event. There was no business being carried on at the premises. Mr. Moore doesn't give any evidence of any. And this point wasn't taken below. Mr. Petts, in his skeleton argument, which is at
Core Bundle 12.
I'm grateful, it's the final tab in the core. Is page 153 on his submissions on adequacy of damages for the defendant, paragraphs 43 and 46. He's saying D is in the process of setting up the property to be occupied by the purpose carrying on the business of Nursery. And completing the formalities for D to be permitted to carry on that business, which would be sufficient to satisfy the requirements of the Act. And at 46, 3 paragraphs further on, he says, if C's application is granted, D will not be in occupation of the property for the purposes of the Act. D will not only lose its superior lease, but also the opportunity to run the nursery business. So the nursery business isn't something that's being carried on the premises by this time. It's an opportunity to do so in the future. And it's quite clear that Mr. Petts' position, this isn't a criticism, it was absolutely the only reasonable position he could adopt in his submissions, that that if the injunction were granted, Avondale wouldn't have been in occupation, and that's as at the date of the hearing before Mr. Justice Leech, 8th of September. So my learned friend cannot really now say that there's anything that's been done in that period to have acquired security of tenure, which again goes both to detriment and of course to the nugatory nature of the appeal, because it would be hopeless. We don't have to speculate. He says, well, my client should be able to take its chances with the council. Well, there's no chances. It cannot realistically say, and indeed has already said that it hadn't carried on. It cannot realistically say that it carried on any business during the period to date, and indeed it accepted that below. So there are no chances to take, if I can put it that way. My learned friend has a hopeless case against the borough in that respect. returning to ground 2 in the estoppel and periodic tenancy, we say that the judge was entirely right to conclude that there was a serious issue to be tried on the respondent's claim to a periodic tenancy. As your lordship's already indicated, it is the conventional and obvious and well-trodden path in case law that a party that goes into occupation or continues in occupation after the end of a lease or goes into occupation under a void lease does so once it is under the once it pays rent and that rent is accepted, is almost certainly going to be held under a periodic tenancy, unless you have an instance such as in Jarvard in Akil, where they are still in the throes of negotiation for a lease, and they might be taken in those circumstances to have had a tenancy and will. But no one is suggesting here that on these facts a tenancy sufferance or a will would have arisen. If I may take it that proposition is relatively trite, I may not need to take you to the various cases, examples of void leases leading to findings of entry under void leases leading to periodic tenancies. But there are one or two that bear further consideration because they, in the course of finding that a periodic tenancy had arisen, and at least 2 instances that I relied upon before you, estoppel was also considered and rejected. And the first of those is the case of Mitchell, which is in the authorities bundle at tab 31. Decision of the Court of Appeal in 2014. The leading judgment was that of Mr. Justice Barling, sitting in that court. The background facts are at page 421 of the bundle, paragraphs 5 and 6. And it states that between 15th and 25th of April 1957, Lawrence's father, Mr. Arthur Mitchell, executed a deed of gift in favour of Lawrence in respect of 1,200 odd acres of land. The point about this is the father then later purported to grant a lease of a cricket ground to the trustees of the cricket club. It says at paragraph 6, on the 10th of June 1947, Arthur entered into a written tenancy agreement, demising these 4 areas of land to 3 gentlemen who are the trustees of the cricket club. And Arthur Mitchell purported to be the landlord, which was an impossibility because he'd already gifted away the land to his son. Over the page at paragraph 10, it gives further background. In the 3rd and 4th sentences of that, in addition, the letter stated, since the agreement was entered into, the property has been made over to Mr. Arthur Mitchell, by Mr. Arthur Mitchell to Mr. HALV Mitchell, and we should be obliged if he would make future payments of rent.
That's Lawrence, is it?
To Lawrence's agents, yes. So Lawrence's, so they are, the tenant is told that since entering into its lease, the freeholder had changed. But of course, as is stated in paragraph 11, that statement was not, of course, accurate, as the gift of the land to Lawrence had taken effect before the entry into the written tenancy agreement. This inaccuracy has to a great extent shaped the present dispute. And then it's paragraph 14. It's common ground that the club paid a rent of £1 a year to Lawrence's agents until 1964, and then it continued to do so at the rate of £20 a year until 1974. The judgment below that the Court of Appeal reviewed is set out at paragraph 24 at page 425. And it's point 6 over the page of 426, which is relevant to where it says the trustees were not stopped by convention or otherwise from denying the tenancy between themselves, from denying that the tenancy between themselves and Lawrence, which had admittedly arisen in 1947, was granted by the written tenancy agreement rather than by implication from payment of an acceptance of rent. There had been no representation at all on the part of the trustees, and it could not be said that either party had acted upon some common assumption as to the legal analysis of how the tenancy between them arose. The solicitor's inaccurate statement in the letter of 2nd October 1947 did not give a clear indication one way or another as to that legal analysis. So the tenant in that case successfully argued that a periodic tenancy had arisen. It wasn't stopped from doing so by reason of any communication between them. And the reality was they just hadn't turned their minds to the question, just as Mr. Delaney didn't in this case.
Yeah.
The Court of Appeals, the important part of the Court of Appeals decision is at paragraph 54 onwards at 433.
54, did you say?
Paragraph 54, my lord, yes, at page 433. Which starts, in our view, the argument based on this form of estoppel fails in either event. I should say from the above, you can see that it's a discussion of estoppel by convention, either is in a contractual or non-contractual setting. The judge was clearly correct in describing as subtle the distinction between a tenancy granted by the written tenancy agreement itself and a tenancy granted by implication from the payment and acceptance of rent, terms of which are the same as those set out in the written tenancy agreement. He was similarly justified in finding that in 1947 no one would have given the slightest thought to the correct legal analysis of what had happened, let alone to whether it was one that was one rather than the other of these alternatives. Certainly neither Lawrence nor the trustees would have done so. It would have been regarded as entirely irrelevant and uninteresting. Indeed, it was so regarded until the trial before the judge, when the presenting issue concerning the possible effect of paragraph 5 of Schedule 1 arose. Causing them, well, there's some degree of parallel here, in that Mr. Delaney certainly, her evidence is she's running a school. She didn't advert to the significance of Clause 9. And that's the reason why the matter arose relatively late in the day when she had cause to go again to solicitors, which wasn't until the prospect of being evicted from the school came about relatively late in the piece. At paragraph 55, it follows in our judgment that the learned judge was correct to hold that there existed no common assumption as to legal analysis. For the same reason, there could be no such assumption by Lawrence, which was unequivocally and unambiguously acquiesced in by the trustees, or vice versa. Similarly, the judge was obviously correct to hold that neither party had acted upon any such assumption, which did not exist. In those circumstances, it could not be unjust or unconscionable for either the appellant or the respondents to seek to establish their preferred legal analysis now. And we say, my lords and ladies, so here, Mr. Delaney hadn't turned her mind to Clause 9, it hadn't been drawn to her attention. Mr. Moavin may have been aware of it, and that would go to affecting his conscience, but hers isn't affected, and there is no injustice in her being allowed to rely on the true legal position now, when she's taken, more recently, when she's taken legal advice and the status of her nursery school was in jeopardy. Finally, at paragraph 56, it will be noted that as to the appellant's criticism of the judge's analysis of the actual legal position, we agree with Mr. Jordan that the judge's analysis was a conventional one, where there is a lease which, for one reason or another, is not operative, and rent is paid and accepted as periodic tenancy on such terms of the lease, which are not incompatible with such a tenancy, can be created. So, in my submission, that's merely a statement of confirming my submission to you that obviously it's the conventional approach that a periodic tenancy arises on the payment of rent, and that's described as the conventional approach here. The second of the two cases in which estoppel is touched upon in the context of a periodic tenancy arising is the case of Hutchison, which is a first instance decision, and which is at tab 28 of the bundle. It's a decision of Mr. Justice Peter Smith. The background facts are set out on the first page at 367. It's says the tenant was an industrial caterer that occupied certain units of the landlord's industrial estate in East Sussex. The case actually related to one of those units, Unit 15. At the foot of that page, it says the landlords contended that in the week commencing August 15, 2005, the tenant had already agreed to take a new lease of Unit 12 for a term of 3 years with an annual rent. I think 3 years may be an error because actually, or at least
So
it
it's
was
new lease of Unit 15 for a term of 5 years.
5 years.
Third line.
And in the head note, point 4 on page 369, paragraphs 4 and 5, the oral agreement in respect of Unit 15 was void because it was for a term of 5 years. So it couldn't have been created by parole. The tenant could not be estopped from relying on the 1989 Act. Obiter observation of Lord Scott in Colin Yeoman's Row applied. However, on the court's finding, there was no dispute about the terms of the tenancy of Unit 15, and by entering into possession of the unit under a void agreement and paying annual rent, or annual or possibly quarterly periodic tenancy arose, the notice given by the tenant was ineffective because it did not expire on a quarter day. So a similar argument that was being advanced here is there hasn't been termination of periodic tenancy, so my client was still entitled to occupation. But an argument on estoppel was rejected on a different basis, which is a legal basis of whether, which your lordship touched upon during my learned friend submissions, as to whether an estoppel can be employed to outflank statute.
What do you say about that?
We say it can't. It's quite clear that it can't. And there are two bases for that. So that the first your lordship has already identified, which was it would have the effect of effectively denuding the respondent of the protection of the 54 Act, which can't be done. But there's another point, which is if the estoppel is taken to its conclusion, what my learned friend has to say is that notwithstanding the absence of a deed, that when my client went into occupation on the 18th of December 2014, it did so under an 8-year lease, which is an impossibility because the law requires a lease of that duration to be made by deed. So
just say that again.
Well, what my learned friend is
You
having
have to say when your client went into possession on the 18th of
December 2014.
December, yeah.
But effectively, as I understand the appellant's case, it's saying that we are stopped from denying the subsistence of the written lease dated 9th September 2014.
Even though it didn't in fact exist.
Even though it didn't in fact exist, we are stopped from denying its existence. And we are therefore, our tenure was a fixed term of 8 years. Now, if estoppels were entitled to operate in that way, you would be bypassing statute, which requires a lease of that duration to be made by deed. Effectively, in any case where parties entered into occupation under a void lease, because it lacked formality, let's say, the answer would be to say, well, if you both treated it as being existing because you subjectively treated it as so, and there's something crossing the line, then the law will create fixed-term leases by estoppel, which undoes the Law of Property Act, which requires it to be made by deed. So there are two branches to that argument, that estoppel cannot be employed to outflank statute. Firstly, outflanking the 1954 Act, and secondly, it would be outflanking the Law of Property Act, Section 52, which requires, if I have the right section, which requires a lease of a lease of this duration to be made by deed.
I suppose you would also say Section 2 of the 89 Act, which requires an agreement for lease to be written.
Yes.
So your submission is you can stop yourself into a lease of 3 years or less, but you can't stop yourself into a lease of more than 3 years.
Well, I have to logically accept that it couldn't apply. That same argument couldn't be applied in a shorter lease, but a shorter lease could be made by parole. So you wouldn't have that same problem in the first place, because whatever it was crossing the line would amount to sufficient evidence of an agreement, presumably, that you had a lease, so the problem wouldn't arise. It would be
Mr.
artificial.
Holland's answer to your first objection, by reference to the 1954 Act, is that the lease which is being held, being as it were upheld, lawfully excluded that Act. Isn't that a good answer to that objection?
Sorry, my learned friend's argument was
correctly
to say...
understood that. He says, well, there's no problem about outflanking the 1954 Act because the lease that is being upheld, i.e. that you are being stopped from denying, lawfully excluded the relevant provisions. Now, isn't that a good answer to that first objection? Doesn't answer your second objection or my Lord's third objection. But what's wrong with that analysis? That's as I understood his answer to be.
Well, the material effect would be the same. I think the problem in logic may lie in the sentence, it's upholding the written lease, because the written lease doesn't exist. So what you are doing effectively is creating a fiction by estoppel, which does have the effect of outflanking the protection of the 54 Act.
Now, the convention is that the lease. Yes, I see. Right. Well, you say that it's because it's completely fictitious. It doesn't work. The argument doesn't work. I'm not sure that.
It's holding the parties to something that didn't in fact exist by effectively gagging them from arguing otherwise. It doesn't create a lease where there was none, but it would prevent the party who is stopped, the party who has induced reliance, from saying otherwise, wouldn't it? I'm not sure that's the same thing as saying that the lease, the written lease of 9th of September 2014 is somehow given life. It's not. It doesn't. It terminated. It's a nullity. What you are doing is creating a new set of rights arising in equity, is the argument, on the basis of the justice of the situation, or it's unconscionable otherwise. A new set of which would outflank the 54 Act. I should, for completeness, take you to the passage where Mr. Justice Peter Smith dealt with the 1989 Act point and the estoppel outflanking statute. This is page 381, paragraph 64 and 65. The agreement for Unit 15 is void because it falls foul of the provisions of Section 2 of the 1989 Act. Claimants address this in two ways. Firstly, they submit the defendant is stopped from denying that the agreement is void, and it relied on various assurances.
But this is estoppel by representation.
This. I'd understand this to be estoppel by convention, but in my submission, the same principle would apply whichever the nature of the estoppel would be, because it's an estoppel being used to outflank statute is the same point. Reliance is placed on common yeoman's row, and it's dealt with at paragraph 68 of the judgment. It says, however, I agree with counsel, and accept and follow his present view that an estoppel cannot be used for asserting that an agreement void for want of compliance with Section 2.
Not sure that's right, is it? There have been plenty of other cases since, Yaxley and Gotts, for instance, which says you can rely on proprietary estoppel.
In proprietary estoppel, yes, my lord. But this isn't the case.
Complied with Section 2 because it's akin to a constructive trust, or is a constructive trust.
Yes, I mean, proprietary estoppel is the one exception to the sword, not a shield. Shield, not a sword, rather. principle of estoppel. It's its own species of estoppel that does create rights, and therefore has been accepted from that principle. There was obviously the suggestion that and may still be in the case of a business relationship with proprietary estoppel, where you would expect people to advert to this. But in the case of other forms of estoppel, that it is still the presiding view, and I've included in the bundle Michael Barnes's extract from Michael Barnes's book on estoppel, where he, in my submission, accurately summarises the position. That's at the final tab of the bundle, tab 42 of the authorities bundle.
Yeah.
This is his first edition of
Mr.
2020.
Holland has shown us this.
Yes, and the relevant passages are marked up, and he refers to Keane and Holland, which is also referred to in Tinkler.
Yeah.
And it's those passages that I've marked up, that I won't read out, but leading to the conclusion, which is at 536, page 655. The examination of the present question is bound up with a more general question of whether and when an estoppel can in effect override or contradict some statutory requirement or restriction. On this question, the fundamental principle is that estops generally, including estoppel by convention, cannot operate as to contradict a statutory provision, so cannot have the effect of rendering enforceable an agreement which is made unenforceable by reason of non-compliance with some specific statutory provision or restriction. I invite you to find that's an accurate summary of the position from Keane and Holland, which is also included in the authorities bundle, and would apply here not only as to the 54 Act protection, but the very principle of creating a lease that needs to be made by deed by estoppel. As I say, it would otherwise be an answer in almost every case where a periodic tenancy would arise, and indeed in the numerous cases in which it's been held to have arisen, to have created the lease that was void, effectively recreated it by estoppel. And it hasn't. There isn't any case of which I'm aware that the argument that my learned friend is advancing has ever been made, or indeed succeeded, that you are stopped from denying a fixed term lease. I think that's an unprecedented submission. I'm not aware that he doesn't rely on any authority in which that's ever been found. And I say the reason is likely to be that it's an impossibility for the very reason that the estoppel won't outflank statute.
And there's a reference in Michael Barnes's book to action strength, which is about oral guarantees, in which the House of Lords said you can't make an oral guarantee binding by estoppel because
Statute of frauds.
Statute of frauds.
My lord, yes. There is another example that I think is referred to in the bundle, which may come back to me, but it's there is of course the Keane case, which is the effective Agricultural Act, which couldn't be bypassed.
Yes, but the rationale for Keane is slightly different because that's where there's statutory protection for a weaker party, whereas statutory frauds and the Law of Property Act are just all about formalities. They're not about trying to outflank some protection given to one of the parties. It's
about legal certainty.
It's about formalities. Yes.
Whereas the 54 Act is designed to give protection.
Yes. Well, my lord, we have one of each, if I can put it that way. The estoppel that my learned friend tries to raise would outflank an act designed to protect a party who has gone into possession and paid rent and had that rent accepted for a protracted period of time, and can expect it, that has certain rights attached to that. And one of those is security of tenure, 54 Act. And the other, which it would outflank, is more akin to the statute of frauds, as his lordship says, which is a formalities point. Michael Barnes's book he deals with both types in the passages that have been highlighted. He deals with both mere formalities.
Sometimes formalities can be outflanked by estoppel. Isn't there? There's a case, isn't there? I think it's called Shah and Shah, where somebody was stopped from saying that a deed hadn't been sealed or something along those lines, even though that's what the statute required.
I suppose that might have been an evidential estoppel.
Well,
Whether it-
estoppels.
Without that case in front of me, whether that it doesn't seem to be the prevailing position in cases of this type, especially in a landlord and tenant situation that we're dealing with and the authorities that we're referring to. May I take your lordships and ladyship to Tinkler? And
I mean, in a sense, your position is the same as it would be if parties had agreed and proceeded on the assumption that the document was a license when in fact it was a lease. You can't be stopped from saying, well, we all agreed it was a license.
Well, it is what it is.
Therefore, statutory protection doesn't apply.
No, you couldn't outflank it in that instance, nor in this.
Am I right in saying you're not asking us to decide this question, but simply that there are serious arguments?
Precisely. By the way, it's not. I think it's my learned friend's case. He's inviting you to make final findings on these matters, which I say is impossible given. Well, to take the example of the estoppel on which we're now dealing, depends on matters of conscience and justice of the overall case, the state of mind of Mr. Muavin, his motives for his conduct, whether his conduct is impugnable, whether he comes with clean hands, in whether he was acted in a way that was misleading towards Mr. Delaney and what he choose to centre and what. Those are all matters on which we say would prevent you from making any finding as to whether an estoppel has arisen in this case.
Yes, but this legal argument.
Oh, I'm sorry.
Is even if the factual ingredients were there, you say there's a serious argument to be had. You're not inviting us to decide the question, or are you?
I'm sorry, my lord, for my misunderstanding. No, I'm not, and I don't need to for the purposes of our response to this appeal. I was going to take you to Tinkler. I appreciate you've been taken to it already, but it's at tab 37 of the authorities bundle. It's a case about a tax inquiry. Notice of the inquiry hadn't been sent to the taxpayer. It had been sent to his accountants, who communicated with the revenue as if the inquiry was valid, and the question was whether the taxpayer was stopped from denying the validity of the inquiry process, which was then treated as being on foot, even though he hadn't actually been served, which was a requirement. It adopts the bench dollar test of Mr. Justice Briggs, as he then was. But there's a passage relating to Keane and Holland at page 571. 571 of the bundle, paragraph 33.
Yeah.
And this is makes a general proposition that follows on from the point on which I was just addressing you. The decision in Keane and Holland is of primary importance in laying down an estoppel by convention, like other estoppels, cannot apply in certain circumstances because it would undermine a statute. The question was whether a tenant was stopped by convention from alleging that a tenancy agreement fell within the protection of Section 2.1 of the Agricultural Holdings Act 1948. In a situation where the landlord had agreed to the tenant's continuing occupation of the property only on the basis that the tenancy would not attract security of tenure afforded by the Act. The Court of Appeal held that the landlord's argument based on estoppel by convention could not there succeed, just as an express agreement could not outflank the mandatory provisions of the 1948 Act, so estoppel could not do so. I shall return to that central aspect of the decision later in this judgment. But Overton, Lord Justice Oliver, went on to say that in any event, the requirements for an estoppel by convention were not satisfied on the facts because the landlord had acted on the mistaken view that the protection would not there apply for reasons which had nothing to do with the defendant, the tenant. True it was that both parties had entered into the contract between them, mistakenly thinking that the protection afforded by the 1948 Act did not apply, and the tenant knew that the landlord would not have entered into the contract had it known of its true legal effect. That was insufficient for estoppel by convention. And this comes back to the crossing the line, this quote that for reasons which had nothing to do with the defendant. And this comes to the point regarding crossing the line and inducing, if you like, reliance on it. That if Mr. Muavin had come to the view that the written lease was subsisting in spite of clause 9. I say if because that, as I've already submitted, is a matter for trial. Then estoppel would have no role to play if he had reached that view for reasons which had nothing to do with the defendant. In other words, if he reached it of his own mind. And there, Mr. Moavin is rather undone by his lack of candid evidence. Because he doesn't say what it was that induced him. Well, first, he doesn't say he did believe that the written lease was subsisting. He says something slightly different, subtly different, but it's significantly different, as I pointed out. But he doesn't choose to say that I did it because of something that the tenant did or didn't do. And without that, the estoppel just doesn't get off the ground.
Well, I think the better point, potentially, speaking for myself, is that you just don't know what the evidential picture will be. It could be that there's sufficient there if, yes, he formed his own view independently, but additionally relied on the comfort of knowing or believing that your client took the same view. So it just all depends, doesn't it? It could be very nuanced.
Well, absolutely, yes. And I think as that feeds into my earlier submission, that it's one possible evidential outcome, that it could be that Mr. Moavin would say, I wasn't sure, but I was encouraged.
By the fact that she took the same view or a different view or whatever.
But and the problem with that, of course, is that he doesn't say that.
I understand that.
And we won't know what he does say about that.
Even if he had come to the view independently, if he was reinforced in that view by something that Mr. Delaney did or said, that might be enough, mightn't it?
Possibly, my lord.
Well,
but that would...
I think it probably would be enough. If you look at paragraph 51, what Lord Burrows says.
Yes, I would accept that...
Strengthened or influenced in its reliance on the common assumption by what the other side has, the other party said. So
yeah, if he'd formed a view which is then reinforced by the other party, I accept that might have happened. But in these particular circumstances, that would require an inquiry as to Mr. Marvin's state of mind, as to what Mr. Delaney was thinking. Because if he were to say, well, I thought it, but then I was reassured by her position, she's been kept in the dark. He can't draw that comfort from her ignorance, if you like, because he knows that her conduct might be equally consistent with her just not having looked at clause 9. He won't know whether she's saying to him, I think this lease is subsisting. It might be that she just hasn't thought about it. So how much comfort can one draw from that? Where you harbour the view, which you may harbour the view, I think the written lease is subsisting, or indeed, I know it's not, but she seems happy with it, so I'll adopt that. I mean, there are various, I suppose, what I'm building up to, there are various permutations of what he would and wouldn't, could, that might come out in evidence. But the most important and bottom line is that he doesn't choose to say any of those things in his evidence. He hasn't said, I was reassured by Mr. Delaney's behaviour. He hasn't said whether or not he was adverting to clause 9, despite him being the one who had taken the steps to try and procure the deed of variation, from which we can infer he knew about clause 9. He doesn't say whether he knew that the lease was terminated, was taking his chances. He doesn't say. The various, he chooses not to say. And that choice not to say is his undoing, in my submission. Because he can't now invite this court to find not only that there is an estoppel, but it's unarguable otherwise, which is a bold proposition in my submission. The 5-point test is at paragraph 45 of Tinkler, subject to the qualification. I know your lordship pointed out that there should be something that crossed the line, that should be inserted, if you like, into the Roman 1 of the 5 propositions in paragraph 45 of Tinkler. So it's not enough that the common assumption upon which the estoppel is based is merely understood by the party in the same way. It must be expressly shared, to which one reads in, it must have crossed the line. Something must have crossed the line. I've already made my submissions on that. In my submission, there is room for significant doubt about whether there even was a common assumption. given the different states of knowledge of Mr. Moavin and Mr. Delaney. Secondly, the expression of common assumption by the party alleged to be stopped must be such that it may be properly said to have assumed some element of responsibility for it, in the sense of conveying it to the other party on an understanding that he expected the other party to rely upon it. Well, of course, it's a rather difficult thing to be cast upon the tenant in this case, where they are ignorant of their rights. It cannot be said of Mr. Delaney's that they were making effectively a representation that they would not rely upon the fact that they had a periodic tenancy as opposed to the lease being subsisting. Because, as a matter of fact, Miss Delaney didn't know that she had that right, much like the parties in other cases, such as the Mitchell case, didn't know, didn't turn their minds to the point back in the 1970s when they were granted a lease at their cricket ground. Didn't know. So the idea that she could be held responsible for assuming responsibility, as if to say to the other party, I know this is a bit of a mess and I have a periodic tenancy, but I will not rely upon that in the future. To attribute that, a representation to that effect, is just not available on the facts of this case.
Well, is that the relevant assumption? The relevant assumption is not you don't have a periodic tenancy. The relevant assumption is you do have a sublease expiring in August 2014.
Yes, but the estoppel is to prevent her from saying otherwise.
Do rather. Yeah.
Yes. I mean, that not only do I have a sublease, but that's all I have. I won't ever say otherwise.
We can't have two leases. She can't. She's in occupation and paying rent. She's not paying rent under two separate leases. So if the estoppel is, the assumption is that the lease she's holding under is the fixed term tenancy, that's inconsistent with thinking you're holding under a periodic tenancy.
Well, yes, I accept that point, my lord, but in this case, she, as a matter of fact, she hasn't actually done anything that is an unequivocal representation.
That's a different point.
Yes, it is, yes. You were taken to a series of emails where she requires the fixing of a pipe.
Yeah.
She talks about rent reviews. All things which were equally consistent with the periodic tenancy, or put it this way, not inconsistent with the periodic tenancy as with a fixed term lease.
I think she also refers at one point to my lease coming to an end.
She does it eventually. She talks about the lease. Well, she talks about the lease coming to an end, but that equally could apply to a periodic tenancy.
Not on a particular date.
She doesn't state a date at which it comes to an end until very late on in the communications between the parties. Indeed, I think it's only the involvement of solicitors at which point. So if one looks at you were taken to various communications.
Page 289.
Bear with me. 289. So
209.
289, sorry.
Yes. But before that, she's not said anything that isn't asking her landlord to repair a pipe. Isn't a representation that she has. She occupies under a written lease for an 8-year period commencing on such and such a date. It's just inviting the landlord to fix a pipe, which is equally consistent with the periodic tenancy. What's the only point at which it's inconsistent with the periodic tenancy is the one term which can't be incorporated into the periodic tenancy. So the periodic tenancy that arises by the conduct of payment and acceptance of rent will be on the terms of the void or terminated lease in every respect, bar one, which is its fixed term. And so the only representation which is...
And the contracting out.
Well, you could... Yes, because it necessarily follows by operation of law that you can't... The periodic tenancy can't be. I accept that. But there isn't any correspondence about contracting out. The correspondence about various things are equally consistent with a periodic tenancy that incorporates all the provisions of the written lease. The only point at which it becomes inconsistent, my lord, is where there's a reference to the 8-year term and it coming to an end on the 29th of August 2022. And that doesn't happen until the document at 289. But the important point about that is its date, the date of this email, which is the 31st of March 2022. Now, by this time, there can't be any detriment, because my learned friend can't say that because there was no possibility of terminating the periodic tenancy at this time. It was already too late.
How long do you have to give notice? Do you have to give to terminate a quarterly tenancy?
Well, if it's an annual tenancy, it's...
Why would it be an annual tenancy if you're paying rent quarterly?
The rent was paid quarterly but calculated annually. And I think there's some division. Whilst you don't have any authorities cited before you, I think there's some...
So it would be 6 months in any event, on the assumption it's a 54 Act protected tenancy, I think the minimum is 6 months.
But the other answer to your point, well, always, even if it's quarterly, you'd have to be giving notice to terminate on the next quarter day. So you wouldn't be able to give 3 months' notice to terminate on the 25th of June.
You don't have to give notice which is valid at common law if you give a notice which is valid under Section 25.
But the Section 25 notice has to be 6 months.
Has to be six
6
months.
months.
Yeah.
So if you
Which
do
would
the
take you
on
into the
the
end
1st
of...
of April. It would take you to the 1st of October.
Yeah, so there's no detriment by this. Insofar as this is a representation intended to be relied upon, that the lease ends on a particular date,
Yeah. And
there can't be any
query
detriment flowing.
at this stage whether Avondale is the competent landlord anyway.
It may not have 14 months still to go.
Yes.
So it may not have been in a position to serve a Section 25 notice at all.
Well, that would also follow. Well, I was going through the propositions in Tinkler, and I got to the assuming some element of responsibility that was intended to be relied upon, that a particular lease, as I say, nothing before that time is inconsistent with the periodic tenancy, the communications that pass between the parties.
The rent review may not be entirely consistent with a periodic tenancy, but it certainly one would normally not expect to see a rent review in a periodic tenancy. You'd expect to see a rent review in a written lease for the reasons Mr. Holland gave.
Well, that depends on postulating a periodic tenancy which you've negotiated. This one that's arisen by operation of law on the conduct of the parties.
It would incorporate a rent review because it's not repugnant, even though it would be pretty unusual to agree it expressly.
But it's not inconsistent, which is the test. So, and also just as a matter of practicality, the rent had been agreed with a particular mechanism to it, and that's, it's not sending a message to Avondale of any particular duration, nor indeed of any particular means of termination of this lease. It doesn't say you can terminate this lease will terminate on a date in August 2022. Just saying we need to agree what the rent is. As it happens, those rent reviews weren't actually fulfilled. They sort of fell away. No, the first rent review comes into focus at one point. And I think there's an attempt by Avondale to say, could you pay some more rent? Which the answer is, and I paraphrase very broadly here, the answer is, I don't think that's right, I can't. And then it just sort of falls away, and none of the other rent reviews are engaged. And there's no, as far as I know, there's no correspondence at all on the other rent reviews that happened during the 8 years. No, nothing at all on the other one. Roman 3 of the 5 points in Tinkler I've already addressed, which is that the person alleging the estoppel must in fact have relied upon the common assumption to a sufficient extent rather than merely relying on his own independent view. We obviously touched upon whether the independent view might be reinforced by a particular representation, but not in this case, we say. Fourthly, that reliance must have occurred in connection with some subsequent mutual dealing between the parties. I think that falls within the same topic. But last but certainly not least is the question of detriment. There must be some. I say there's a further question of unconscionability, which is embedded in all estoppel, and particularly the requirement for detriment.
Well, unconscionability is swept up by Mr. Justice Briggs in paragraph 5. Some detriment sufficient to make it unconscionable.
And I haven't taken you to them, and I sense it's unnecessary, but there were obviously the evidence of Avondale's purported intention to run a nursery school was so flimsy as to be fanciful. It was incredible, indeed. That Mr. Delaney's evidence was that on the 26th of August, when the locks were changed, Mr. Moravin approached her so as to try and reach a consensual resolution of the matter, and made the comment, "What am I going to do with the nursery school?" Now, obviously, you can't resolve it. We don't know whether that comment is denied or not, because there's been no further exchange of witness evidence. But that's obviously a triable issue. But that would indicate that Mr. Moravin is quite aware that Avondale is not in a position, and has never been in a position, never crossed its mind that it might run a nursery. It's singularly ill-equipped to do so. Miss Delaney, in her evidence, in her third witness statement, explains how complicated and time-consuming it is to run a nursery business. It's not something you just start from scratch out of the blue, as one might expect. And that's her third witness statement, which is tab 13 of the supplementary bundle. From paragraph 12 onwards, page 346. She says at paragraph 12, the last sentence, there was never any mention of the respondent's alleged intention to open its own nursery school, which is surprising given the registration requirements imposed on providers of such services. And she goes on, from her experience in the field, to describe what you need in order to open a nursery school. One of the key elements is registration with Ofsted. You apply to be registered. You need to meet all the requirements set out in the statutory framework. Every application for registration as a new provider involves a registration visit by an inspector. And she goes on to explain the various steps that are required. And she makes the point at the end of paragraph 30, there's not been any discussion or proposal from the respondent, the appellant on this appeal, regarding Mr. Delaney's fixtures and fittings. So it wasn't going to step into Mr. Delaney's shoes, because it never approached Mr. Delaney to say, can we purchase all your fixtures and fittings? It would have to be fitted out from scratch, which Mr. Delaney had given evidence in her earlier witness statements that cost her £250,000. She talks in paragraph 14 about the obligations to staff and whether there be any transfer of employment obligations towards them. She talks in paragraph 15 about liaison between providers in maintaining continuity of care if they wanted to continue this nursery school. Paragraph 16, she says, at no time did Amir, that's Mr. Moravin, discuss or indicate to me that the respondent intended to open a nursery school when the applicant's lease expired. Indeed, I had a discussion with him in the afternoon of 26th of August 2022. This is the conversation to which I just alluded. When I went round to the property with the applicant's head teacher to see what was happening at the property, in the course of the discussion, Amir said words to the effect that it wasn't too late to sort things out, and my lawyer needed to discuss the situation with his lawyer. I responded by thanking him for the 8 years that we'd worked together, that I was done with him and proceeded to walk away. Amir then said as we were walking away, what am I going to do with the nursery school? We say this is consistent with the picture that Avondale is and has only ever been a single vehicle property holding company, professional landlord. It has no staff that have any qualifications to run a nursery. Mr. Moravin doesn't personally, and has never had any serious intention to run a nursery, nor could it do so. The suggestion is fanciful and obviously a point devised for the strategic purpose of trying to oppose the injunction application. she says at paragraph 18, the timescale for opening the nursery also seems to me to be a huge underestimate. She says, I personally opened 3 schools in my 26 years of working in education. Preparation, planning, and registration process has taken approximately a year to complete. Officer's current advice indicates the aim to register a new provider within 25 weeks, but it might take longer. She goes on to talk about evidence to demonstrate that the new provision will satisfy all the requirements set out in the statutory framework. None of this preparatory work appears to have been done. Over the page, paragraph 19, applicants' policies, procedures, operating practices, and manuals are the product of 26 years' work, constant process of improvement, and of course, none of which Avondale has given any evidence that it's embarked upon. And last but not least, Avondale had declared itself to be a dormant company that wasn't trading. The evidence before Mr. Justice Leech, in the form of its accounts, was that it had only £100 cash in hand. Those accounts are in the bundle. I noticed the 2022 accounts, so they're at page 142, 143. That Mr. Muavan had chosen to declare, which of course he's under an obligation to do accurately, the status of Avondale Company, and these are the accounts to 31st of August 21, which stated £100 cash at bank and in hand, and that's the sum total of the net assets and no trading. There's a dormant accounts. I add, and I noticed only recently on this point when Avondale made an application that it's abandoned to introduce revised accounts, that omitted from this bundle was the accounts to the year ending 31st August 2022 were also provided to Mr. Justice Leech because they were very new at the time. They'd only just come in. They weren't exhibited to any witness statements, so they were handed up separately. They haven't reached the bundles that you've got in front of you. I have copies if it would assist. But Mr. Muavan was effectively declaring the very same thing that you see here, as at the year ending 31st of August 2022. And he signs it. It says approved by the board on the 2nd of September 2022. It might be easier to pass them up if I may be permitted, if it would assist. I mean, it's the 2nd of September 2022 is the day of the issue of the application for the injunction, which had been foreshadowed. So on the very day of the issue of the application, Mr. Muavan is declaring that Avondale has no assets bar £100. He attended court and instructed his counsel on the last occasion to say, there's 400 and something thousand pounds sitting in a bank account, which there is a page in evidence. But he didn't choose to say what the source of that money was or how it was compatible with what he'd chosen to declare in the returns. That's still a mystery. It hasn't been explained. This 400 and something thousand pounds. It clearly doesn't, on his own declaration, doesn't belong to the company. That's a further reason why Avondale was never in a position to be starting to operate its own nursery business. Although the question of unconscionability is tied up in the bench dollar test with detriment, I would say it's not limited to that. The court would have regard to the wider justice and the effect on the conscience of the circumstances which are said to give rise to the estoppel. And in this case, when the question is one of the fairness, the justice, unconscionability of the nursery school being entitled to resile from an alleged assumption that had crossed the line about term of the lease, one has to look at the wider picture of the conduct of the parties. And Mr. Moavin's conduct would be very much an issue as to how the situation arose in the first place. And in that respect, I would invoke and go back to the correspondence that, at which I started in my submission, relating to the different states of mind between the two. Because Mr. Wavin, in my submission, knew more than Mr. Delaney and may very well have decided to keep it to himself. And when one considers how the conscience of the parties is affected, the cross-examination on those points is going to be very much an important issue, because we say that his conduct is tainted, likely to be tainted, and that's what we would be exploring at trial. Unless I can assist further on the second ground, the estoppel ground, I'll move to the merits test in the time remaining.
You must leave room for Mr. Holland to reply.
I will. I can be relatively brief. I believe in my submission, it doesn't lie in the mouth of Avondale on appeal to say that American Sign Language should be abandoned, if that is what it's saying, because counsel below invited the court to apply the American Sign Language test. In my submission, there's no need to depart from the American Sign Language test because it allows for cases which may be said to dispose of the case finally. In my submission, it's not clear why it is said that this would dispose of the case finally. My learned friend says it would become a commercial dead duck, if you like, if they weren't allowed to re-enter the premises. But given that we can see now that in my submission that wouldn't be the effect of the success of this appeal anyway, I think that point rather falls away. What the most that Avondale had and has is some sort of damages claim or enforcement of the undertaking, saying that it lost this opportunity that has now passed to run a nursery school, which would in turn have given it statutory protection. That argument, leaving aside that we say it's an extremely weak one, untenable one, but it's still available to it.
But isn't that the case whenever the court grants an interlocutory injunction? It will always be accompanied, except in very rare cases, by a cross undertaking in damages.
Yes.
Even if you apply a higher test than is there a serious issue to be tried, unless you're inviting the court to make a final injunction, you're always going to have an cross undertaking in damages.
Yes, my lord, I mean, in this case, the need for a final injunction does fall away because the intermediate lease has expired.
Yeah.
I accept that, but this isn't a case in which Avondale has ever been running a nursery. Its interests were always commercial. It was a figure to be put on it. This lost opportunity to run, this lost profit from this, that it says it would have made had it been allowed back in, and that's still available to it. It's far-fetched, my submission will fail, but that is still that's the position it had at the time of the injunction. It's the position it still has now. And in weighing up the adequacy of damages for the respective parties, Mr. Justice Leech was right to conclude that the incalculable harm would be done to my client if it just had to suddenly shut its doors to the parents and children. But that Avondale's loss was capable of being compensated in damages. because its loss, if you like, it says it would be making the profit that my client is now making.
Is that where the point comes in, so to speak? If you come to the conclusion that the case for one party or the other is overwhelming, such that you can decide it on interim application, do you then start worrying about the balance of convenience, or do you just decide it?
Well, I think, as I understand Lord Diplock's proposal, the decision in American Cyanamid is that you get to the merits and the balance of convenience stage, so that if you answer the first question as a serious issue to be tried in the positive, and damages are not an adequate remedy for the applicant, but that they would be for the respondent, then unless there's doubt about those conclusions, you don't go on to consider the balance of convenience anyway, because you've got your answer. And there's no need then to engage in the merits. He suggests that where it's unclear, you might, as part of that, where it's unclear, and there may be special factors, such as it disposing of the litigation as a commercial reality, where you might pay additional heed to the merits. But his warning is that you should approach that with extreme caution. In American Sign, I think he says that you should only take into account the merits if they're disproportionately in favour of one party over the other. Certainly can't be said in this case. Well, only in my client's favour. I mean, that's the that's American Cyanamid at page 409 of the report, which is tab 15, page 409 of the 179 of the bundle, 409 of the judgment of the report. Having gone through the adequacy of respective remedies and then gone on to the balance of convenience, he says at halfway down A, the extent to which the disadvantages to each party would be incapable of being compensated damages in the event of his succeeding at trial is always a significant factor in assessing where the balance of convenience lies. And if the extent of the uncompensatable disadvantage to each party would not differ widely, it may not be improper to take into account in tipping the balance the relative strength of each party's case, as revealed by the affidavit evidence adduced on the hearing of the application. This, however, should be done only where it is apparent upon the facts disclosed by evidence as to which there is no credible dispute that the strength of one party's case is disproportionate to that of the other party. There's several warnings in there, which is where there's disputes of fact, you can't really meaningfully engage on assessment of the merits. And in a case based on estoppel, which will require examination of the conduct of the parties and the conscience of their dealing, I say an estoppel is all the more unfitting for this sort of interlocutory assessment of the merits. I say, in fact, that the first three questions of American Cyanamid are sufficient to dispose of the case in my client's favour. I would say in the alternative, even if a more rigorous merits test is required on the basis that the case would somehow be determinative of Avondale's rights, then Mr. Justice Leech did engage in that process in a thorough 3.5-hour hearing where he examined and much as the submissions have addressed today, as to how an estoppel convention might work, what its problems were. And he did make findings, which he expressed a view which does suggest that he was applying a more rigorous test, as my learned friend concedes. He did express his view on the operation of the contractual term. He said that it clearly says what it means what it says. The arguments advanced by my learned friend today weren't advanced to him. And then on the estoppel, he explains why there are problems with it. And he finds that the evidence, he accepts the criticisms of the evidence that Avondale were ever intending to run this nursery school themselves. And he finds his word is unlikely. I said fanciful. The judge held that it was unlikely that they were going to run a nursery school. So he has engaged with that more rigorous test. And I say that in doing so, he was right to conclude in my client's favour, having applied that more rigorous test. I think I've already addressed you during the course of my submissions on the pointlessness of the appeal, and I doubt it's necessary to go into the facts. I've briefly touched on the Poynton case without taking you to it and its distinct facts. This isn't a case in which there is any prospect whatsoever, we say, of Avondale demonstrating that it would have been running a nursery business such as to attract 54 Act protection. Less so, still, that it has already done so in that short intervening period. May I take instructions as to Thank you for that time. No further submissions.
Thank you, Mr. Moffat. Mr. Holland, do you wish to reply?
Yes, just on two points.
Yes.
There's some points in these. The first of all is my learned friend's attempt to sow confusion or doubt where I say there isn't. It is in the state of Mr. Nolan's mind as to what he genuinely believed. I've taken you to the relevant passages in the evidence of both Mr. Delaney and Mr. I note that the learned friend doesn't say that Miss Delaney was in any way in doubt, and her clear evidence is, as I've taken you to, that the lease was in existence. The paragraph, I think it's 19, of Mr. Movin's witness statement must be put in the context of paragraph 27, and also of the subsequent documents which crossed the line or which you were taken, in which both parties, in my submission, clearly were of the view that the lease subsisted. My learned friend drew your attention to the letter at 254, which is, of course, I think it's that of the 30th September 2014. And he says, he draws quite a lot from this. And this is a letter from the solicitors that acted for Melcraft, the lessor on sub-lease, to the respondents solicitors. And it's to the solicitors, Mark. Right further completion matter, close the under lease. So they're enclosing I confirm all forward information related to the deed of variation. So both parties, and it cuts both ways, both parties had retained solicitors to an extent at that time. And here is one solicitor telling the other, we'll get the deed of variation. Therefore, both parties could be said at that stage to be aware of the need for a deed of variation. Now, my learned friend says, oh, that must mean that Mr. Mowbray was taking advice. It must mean that he was aware of the effects of clause 9. That's nonsense. At the end of the day, both parties, of course, appreciated the need to get a deed of variation, but whether they were aware of the actual legal ramifications of clause 9 and what would happen if it wasn't is a different matter. And so there's no underhand view to be taken from that somehow Mr. Morgan must have been aware that of the effect of clause 9, and poor old Mr. Delaney wasn't. Poor old Mr. Delaney had solicitors in the same way as poor old Mr. Mulvey. And so you can draw nothing from that. And there's nothing here. At the end of the day, both of the parties clearly asserted that they believed that that the occupation was pursuant to the lease. Both parties clearly behaved in that way as one looks at that. And to say that somehow in Micawberish fashion you should wait until trial and there'll be a massive cross-examination and Mr. Mulvey will break down and say, oh yes, I'm sorry, I knew all along I was deliberately stringing poor old Mr. Delaney along is utter fancifulness. It's ridiculous. And you cannot draw doubt where there is no such doubt. And to say that there is somehow a disparity of somehow poor old Mr. Delaney was in ignorance and thinking that she was unaware of clause 9, that's not the estoppel here. The question is whether Miss Delaney, whether or not she focused on clause 9, and whether or not she was aware of its legal effect, whether she thought her occupation was under the terms of the lease, whatever that meant. It's quite clear from her evidence that she didn't give a moment's thought to clause 9, but that's not the point. Ignorance of the law is no excuse. It's whether she thought she was going in under the terms of the lease. And that's the same with Mr. Mulvey. He may or may not have focused on clause 9, but the question he's given his view, his belief, and that's his belief, and that corresponds with what was with the correspondence that passed between the parties. My learned friend pointed to page 289, as it is said, the first representation that could be said to unquestionably point to a belief in the existence of the lease. But I would say 285, 287 and 288 also point to that. 285, it is March 2021. I think to these. 287 is the one which asserted the lease 7th June 2021 and respectively to rent was then paid, and 288 was March, a text at the end of March 2022.
They refer to my current lease and my existing lease and things like that.
Yes.
Do you say that's inconsistent with periodic tenancy? I mean, I know lawyers draw a distinction between tenancy and lease, but do lay people...
He talks here about the repayment of the security deposit at the end of the term. That's just not a reference to
a periodic tenancy.
Periodic tenancy. And bear in mind, the obligation was on the landlord to repay. If clause 9 is of the automatic effect, which I don't know what the courts could find, but automatic effect the judge find, then there would be an automatic obligation on the landlord to repay the security deposit. There'd be an automatic obligation on the tenant to deregister the lease. Neither of those occurred. So far as the land registry is concerned, there was an 8-year term registered. One sees it.
I wonder about the security deposit. I mean, I can see an argument saying that if you create a periodic tenancy on the terms of the void lease, and the void lease requires a security deposit to be paid and repaid at the end of the term, then incorporating that into the periodic tenancy means that the security deposit is to be paid when the periodic tenancy comes to an end. I mean, I take your point about the registration, that's a different point. Security deposit, not quite sure, so sure.
Maybe, I suppose, again, it's a bit like a rent review provision. I suppose it's not technically repugnant, but it's highly unlikely. In the same way as it's highly unlikely that Mrs. Delaney would have gone in and spent all that money doing the work if she thought she had a periodic tenancy.
Yeah.
Sorry, I say the learned friend's cross-examination point is an attempt to say that Mr. Mulvey has somehow not actually said that he accepted there was, or he thought there was, is just not right. The second point is the Keane and Holland point. I'll make 2 points here. First of all, this is a peculiar situation. We have here a validly granted 8-year term, signed by both parties as a deed, validly excluded from the 1954 Act, and that takes effect. We have a term here which, on the judge's finding, automatically terminates that. We then have 2 parties who go into occupation perfectly reasonably pursuant to the term or at the date envisaged by the term of the lease, which is, on this hypothesis, terminated automatically, and proceed to comply with the terms of that. And the estoppel is to do with the effect of clause 9. What I say is, in recognising the continued existence of the sublease, the parties are estopped by convention from asserting that clause 9 has terminated the lease. And if that's right, the 54 Act, there's no problem with that, because the lease was properly excluded from the 1954 Act and will continue to be excluded. And there's no problem with whatever it is, the Section 56, 53 Law Property Act, because the lease was validly granted as a deed.
So the lease by estoppel is not a new lease by estoppel, it's the old lease, which is granted by deed and excluded from the Act.
That's right. And all you're doing is stopping yourself from relying upon the clause which says it automatically terminates. My second point, I'm afraid, is rather on the hoof, and was rather hinted by or suggested to me by my Lord Justice Lewison, to do with the Shah and Shah case. And that was a case, my Lord was dead right, which it was held that you could stop yourself from denying the validity of deed, which I think wasn't witnessed. But
sealed, I thought, but maybe witnessed. I can't remember.
Yeah, I have a copy here. It's the judgment of Lord Justice Hill. At paragraph 20, he cites paragraph 19, 20 cites from Yaxley and Gobbs, and then he says, Lord Justice Belden states in paragraph 191 that, quote, the general principle that a party cannot rely on the stop on the face of statute depends upon the nature of the enactment, the purpose of the provision, and the social policy behind it. In my judgment, this is paragraph 21, the statement of Lord Justice Belden reflected as it does the judgment of the Privy Council in the Cock-Hoon case is, with respect, an accurate statement of the law of England and Wales. Courts entitled to consider a particular statutory provision, its purpose, and the social policy behind it, when deciding whether an estoppel is to be allowed. On such an analysis, section 2 of the 1989 Act, requiring contracts for the sale of land to be made by signed writing, I do not with respect question the conclusion of Simon Brown in the Gordon case. The section should not, on the facts of the case, be outflanked by an estoppel. I cannot, however, accept the principal statement holds for these laws is of absolute or universal application, and agree the comment of Robert Walker in the Yaxley case in the context of section 2, the general assertion of a no-go area for estoppel would be unattainable. And there's a further discussion on the conclusion that he reaches, I think, and I've only had a quick flip through this, is paragraph 30. I have, however, come to the conclusion that there was no statutory intention to exclude the operation of the estoppel in all circumstances, or in all circumstances such as the present. And he goes on about that was the need for formality in respect to the deed. So the point I make is that the rule that you cannot circumvent a statute by estoppel depends upon what the court perceives to be the public policy behind it.
Well, that's exactly what Lord Radcliffe says in the Cock-Hoon case.
That's what. Well, I only know that because I've just read it in the judgment. My Lord obviously knows it. But in my submission, in these circumstances, stand back. If it is said you cannot stop yourself from relying upon, you can't stop yourself from creating a lease of 8 years without a deed. In these circumstances, that's not the case. We have a document that was signed validly, and the estoppel is simply whether that document continues to be valid. And in those circumstances, my subsidiary point would be, even if somehow the estoppel that I claim does cut across a statutory provision, it's not such in these circumstances whereby the court should declare that the social policy prevents an estoppel in these circumstances. And that will be my solution. I think that's all I have to say.
Thank you very much. Well, thank you both very much for your arguments. We will take time to consider our decision. You will get a draft in the usual way, which is your opportunity to correct our English and our grammar, but no more. It comes with a fierce embargo, which means what it says, so the distribution list is restricted to those whose names have been given to the court before the appeal began. In the light of the draft, we hope we will be able to agree in order disposing of the appeal, but if you can't agree in order, please make short submissions in writing, and we will make the order that we consider to be appropriate. Thank you very much.
All rise.